So you have the agenda in front of you. We're going to start with some commentary from our staff. I'd first like to have Craig Working, our Public Works Director, just provide a very brief history, Craig, on this SBA 124 application. Following that, Angie, if you don't mind, just providing the council and the public with what scenarios we have out in front of us, whether we appeal or decide against not taking action, what that may look like. And then certainly we're going to go to public comments. Just for the record, we do have all your written comments up here on the dais. They've been entered into the public record, as well as the numerous meetings we've had in the past regarding this trail segment as well. So they're, again, all part of the existing public record. Just because some of us do have plans following the meeting, and this was a special meeting that was called, I would like to limit public comment to 3 minutes, if possible, per individual, just so we can try to facilitate an efficient meeting this evening. With that said, I'll turn it over to Craig Working for a brief history on this project for the public's benefit.
Thank you, Mayor. So I'll try and condense the last 42 years into 5 minutes or less. I think everyone's aware that the city was granted an easement for this proposed shared use path back in 1983. There was a path there at one point which established the location and permanency of the easement, but it since fell into ruins. It was basically an untreated wood boardwalk. So in terms of the modern history of this path, back in September of 2022, council voted unanimously to move forward with a raised boardwalk in this easement adjacent to the riverbed path. I will just mention that the preliminary concept of that path was done as a pro bono gift from Bruce Rudy, and so we very much appreciate that. But we did hire TDH, and the design team, that also includes WET, Doug Pettmeyer and Brad Bennett are here from the design team if we want to dig into any of the details of the design submittal. Once that September of 2022 motion was made, we went into more detailed design. Council later in May of 2023, well actually it was in January of 23, enabled staff or directed staff to proceed with the final design, and in May of 2023, the final design and the proposed 124 permit was presented to council, and we were authorized to submit that permit. So the permit was submitted in the summer of 2024, and we've been working with Fish, Wildlife, and Parks for about the last 8 months. The initial application had some issues with the signature page, and so they made us resubmit it about a month afterwards. But since then, we have been essentially in dialogue with Fish, Wildlife, and Parks, answering questions and trying to just clarify, some of the specifics of the permit. One of the main challenges that they had initially was the fact that we only had a 6-foot easement, and we're proposing to build a 10-foot path, and the sections of trail on the north and south side of the riverbed property were essentially outside of that 6-foot easement. So back in February of this year, we redesigned the plan showing those two areas connecting down to the river being 6 feet. That was in early February. It was submitted, and then, of course, just 2 weeks ago, the permit was officially denied. So from our reading of the denial, there's really 5 points that Fish, Wildlife, and Parks made. The removal of trees and vegetation will contribute to instability of the bank. The additional impervious surface will disrupt the stream bank. The added weight of retaining walls on Miles Avenue property will add weight and cause additional instability. They were concerned about the helical piers, which we'd be using for the raised boardwalk section. And the path decking would provide shade for invasive fish. So based on those 5 main points, the denial was issued. They did propose an alternative, which we have analyzed and determined not to meet our goals. It will not be an ADA compliant path, and it also reduces the path to a 4-foot width and sends pedestrian traffic through a parking lot. So we don't feel that their proposed alternative really even comes close to meeting the goals of the city and the public with this plan. So that's kind of where we are today. I believe had a 15-day window, 14-day window to notify Fish, Wildlife, and Parks whether we intend to challenge this. And so because March was a 5-Monday month, we weren't going to have a meeting in time to meet that. So we appreciate you guys meeting tonight on this special occasion. But in order to meet the terms of MCA, we really had to do it in a special meeting. So there's obviously a lot more history, and I'm happy to answer questions on any of the detail. But I think most of the people in this room are fairly familiar with the concept and the project and the history, and I don't think we need to get into that much detail right now. So,
Thanks, Craig. Angie?
Thanks, Craig. You did much better with the details of that EA than I would have done. I will also say they actually proposed 2 alternatives, and one alternative was to do nothing, which they're actually kind of required under MIPA to propose. And the other thing I'd mentioned about the alternative design that had been actually offered to us by the Riverbend HOA, we don't even have an easement for. Years ago, I believe the HOA offered us an easement to make that plan happen in exchange for the actual easement that goes, right in front of their condos. And at that time, we didn't feel like that was meeting our needs. So the alternative they proposed really isn't even reasonable if we don't have an easement, nor do we have, truthfully, much leverage now that this has been denied for Riverbend to give us an easement. So I guess I just mentioned those about the alternatives. So FWP assessed this under the Montana Environmental Protection Act, or MIPA, and the Stream Protection Act. And the Stream Protection Act is pretty interesting because once we receive a determination from FWP that it will adversely affect any fish or game habitat, we have to notify them whether or not we will accept their recommendations or modify our plans in accordance with their recommendations, which this is a really old statute, and now let's go on and see what the rest of it says. And upon the receipt of a refusal to modify, FWP shall determine if it wants the disagreement arbitrated, which is very strange because generally in statutes, the parties can mutually agree to arbitrate. FWP just can't say, yeah, we want it arbitrated, or no, we don't want it arbitrated. So I actually spoke with FWP's attorney and asked if that was his reading of it. He said, yeah, that is my reading of it too, and I think it's as weird as you do. But it's an old statute, and FWP very rarely denies permits. Usually they will, work with the city, and he said he can't remember a time when they denied a permit and they actually had to use this were allowed to use this arbitration provision. If they, I guess, were to accept our proposal to arbitrate, it's a weird process. They notify district judges, and the district judges appoint basically 3 just people, and they decide it. And it's about a 30-day process. And I guess my question to FWP, too, about the technical side about it, certainly I think we can speak about whether or not we feel as though FWP has approved other projects in the state and whether or not their denial of this one is arbitrary and capricious. But I certainly I'm not a fish biologist or hydrologist, or I'm not any kind of ist. So how do we basically rebut what Fish, Wildlife, and Parks factual findings were with respect to impacts on the environment? So my question to FWP's attorney is do I have an expert witness? What do I bring to this arbitration? He's like, I have no idea. So it is a very weird process, but I think it's one we have to go through. I will say that the downside of going to arbitration is it is binding, which again seems strange to me. It seems if they did not find, the arbitrators did not find in a favor, we should have the right to challenge that in district court. But it is, we do need to kind of make a decision whether or not that's the route we want to go. I think there's certain advantages to it. It is certainly more cost effective than filing a lawsuit against FWP, and there's some, I think, legal challenges with suing FWP, not the least of which is they've been, a partner with us in many other projects, and I'm not sure we want to degrade that relationship. There's just, again, some legal issues that I don't want to bore you with, but I mean, arbitration is going to be more cost effective. It's going to be quicker. If we sued FWP, I imagine we'd be in court for quite a while. Although it's kind of strange to have 3 citizens deciding whether or not FWP did its job, I think there's certain benefits as well, and that is that they can see the Whitefish River. I mean, it's a Superfund site, right? Right up there. And I think they might have a little bit less science and more practical knowledge of what the Whitefish River is and how this project would or would not impact the Whitefish River. I guess we could just accept their alternative. Well, the one we can't, clearly, we don't have an easement. We could accept doing nothing and work on another plan. I don't know what other kind of plan we would have. I know years ago they had proposed a 4-foot gravel, and this is the homeowners, had proposed a 4-foot gravel path right in front of the condos. Again, that didn't really meet our needs, and I don't think FWP was super receptive to it, is my understanding. So, I mean, we could do nothing and try to work something else out. We could try to work an easement out with the HOA, but again, I'm not sure that that meets our needs. I mean, I guess we could sue them, but again, it's going to be painstaking. It's going to be, it's going to be costly, and we might get the result we want, and we might not get the result we want. Ultimately, if the arbitrator rules against us, I still think we have some legal theories that we could pursue. But in my mind, it's more cost effective, it's quicker, and I think it puts us in a less risky position to go through with the arbitration. Diana and I have talked all day today, and one of her suggestions was that, before going to binding mediation, or binding arbitration, we feel FWP out and see if they want to have some informal discussions or even a mediation with us and, talk about some of these issues, because part of the problem with this 30-day window that they have is they've taken the position that because that's such a short window, they don't let the public comment, including the city. So I think at this point we haven't really had a chance to talk with FWP about what their findings were. So I am certainly open to any questions you might have.
Thanks, Angie. Any questions for Craig or Angela? Steve?
Correct.
Sorry. I'll repeat the question. Is the statute in question that regulates all this, they can just say, no, we're not going to arbitrate?
Yeah, we can tell them basically we're not accepting their recommendations, that we are not going to modify our proposal, and they can say, well, we want to arbitrate, or they can just say, nah, but we still don't get the permit.
Too bad. Do we have any sense of whether...
I don't really have a sense of it, but I think, their attorney is really easy to work with and he's very smart. And I think for optics, they would probably want to at least talk to us.
Okay. And the other question I have, is there any way to file an extension to where we could meet out some of these issues before we have to determine whether we want to go to arbitration?
I believe so. I could certainly speak to their attorney about that. I mean,
other than this 15-day window of having to do this so quickly, is there a way to extend it a month or 2
yeah,
months?
I could definitely put that out there and we could maybe stipulate to it. The statute's pretty specific and it is a very short period of time. And it's a very short period of time, I think, for us to take, well, not for me, but for our experts to take, a hard look at some of their findings and have some good answers for it. I think that's going to be very difficult for anyone to do in 30 days, 20 days.
Okay, thank you.
Additional questions, Frank?
Angie, I want to see if I understand this correctly. We would give them notice, not that we want to arbitrate, we would give them notice that we do not accept their findings and find them contrary to facts on the ground, I'll say. And that we intend to proceed, is that what it is? And that they are then in the position to say, okay, King's X, you win, or they would say, we'll arbitrate. Is that correct?
You are correct. I mean, I think we could soften it a little bit by saying, we understand it's your decision, but we would like to arbitrate. But that's how the statute reads, Frank, and it's weird. And even FWP thinks it's weird.
Well, what I'm suggesting is that we don't accept your findings, we find them contrary to facts. It's their responsibility at that point to make a decision as to whether they want to stop us.
Correct.
Which is go to arbitration.
Correct.
Or not.
Correct.
Is that correct?
You are correct.
Okay. Thanks.
Ben?
So I read through the report that came back from FWP, and it talks a lot about their views of the drawbacks, I guess I would say, to our proposal. It doesn't seem to talk much at all about the benefits of the proposal. Do you know if the statute that FWP operates under is weighing cost and benefit something that they do? Like, for example, there's no discussion of the drawbacks of their alternative that I can find.
Look, Ben.
I'll just say that the response that we received from Fish, Wildlife, and Parks was very clear that they see their responsibility resting on protection and conservation of fisheries and habitat. And we've tried on numerous occasions to work with FWP back before we even approved the final design had council direction to move forward with final design. We tried to meet with Fish, Wildlife, and Parks to iron some of this out, and what we were told was, well, we're not going to even meet with you unless all the parties are involved. So we had, it filled this room with, Fish, Wildlife, and Parks, the Flathead Conservation District, members of the HOA, a few council members were there, number of staff members, and what we heard from them at that meeting was, we cannot talk to you about this project unless we have a permit application in front of us. And so that's why we submitted the permit. There's been no discussion since the permit was submitted last summer, and we get a denial. So I forget exactly what my point was, Ben, but I think I guess I'm trying to tell you is that they're not weighing the public benefit.
They're not.
They were very strong that we should just have at-grade crossing. We have a crosswalk. Why can't we use that and then just go up miles? And so that's where this project started a couple years ago.
And I will say that there are a few factors that they consider, impacts to social structures and mores would be therefore to be long-term, major, and positive. They do talk about trail connection, but again, as Craig said, I think their focus is more on the river. MIPA requires them to consider some of this stuff, but really the purpose of MIPA is to protect the environment, so.
Yeah. Do you think they have a full and adequate understanding of how important this is to the community and the benefits that stem from it?
Personally, I do not, no. The FWP staff that we deal with directly does not doesn't have a good grasp on how important this is to the community.
And so if this extends into arbitration, under what criteria is it going to be decided? Is it a cost-benefit trade-off? How does it go?
There's absolutely really no guardrails on how it's decided at arbitration. Honestly, there's not. There's no case law. The guy at FWP, they're lawyers, but as far as I know, we've really never done it, and I don't know that he's been around, for 20 years or something, but, that's a really good question, is how are the arbitrators going to decide it? And there's really no guardrails, there's no case law.
If it's random citizens, I know from my own experience on jury duty, they give you jury instructions that tell you exactly how you're supposed to evaluate what's in front of you. What do you think a random citizen's gonna?
I have no
Thank you.
idea.
It seems like something we should talk to them about before we even go down that path, doesn't it?
Well, and again, I think that was, when Di and I talked today, that was maybe one thing that we would want to talk to them about is, hey, you guys haven't been involved in this process. We certainly haven't been involved in this process. So let's talk about what this process really looks like, so we're on the same page when we're going into binding arbitration. So, and I don't know if they'd be willing to meet with us and do that, but again, the lawyer I've worked with has seemed very reasonable and accommodating, and I think he sees the same problems with not necessarily the EA, but with the process set forth in these statutes that I do, so.
Just to follow up on Ben's comment, it's interesting that the state elected to shuttle this through via checklist EA, which speaks volumes, in my opinion, to the scope of the project. I mean, typically when a project's evaluated under MEPA or NEPA, it either gets slated through as an EA checklist or elevated to an EA or an EIS if substantial impacts are anticipated. And to Ben's point specifically, they are required to evaluate the direct, indirect, and cumulative effects on the human environment as well as the natural environment. In this case, to Ben's point, they did not analyze the no action or their alternative action in the same framework as they did our proposed action. And that's a major misgiving of this EA. And I don't really want to spend a lot of time this evening picking apart the environmental assessment, but just for the record, I questioned some of the conclusions they arrive at regarding the physical and aquatic impacts, but notably no mention of the human environment, and which takes into consideration the social aspects that have been discussed by our public as well as the council and staff. So my personal opinion is the EA is lackluster at best, but again, I don't want to dive into too much detail on the EA. Giuseppe, question?
Yes, thank you, Mayor. Angie, you're on the spot. Anybody, a person or a company or a public body like the city, which in Montana needs to build something that is over waterways, I'm simplifying, I'm trying to clear the process, needs to obtain amongst the other permits a permit called Stream Protection Act number 124. Am I correct?
So you're mostly correct, yes. So if you're a government entity, you're required to obtain a 124 permit. If you're private, it is called a 310.
Yeah, I remember the 310 story with our neighbors. Okay, so that's one of the requirements before a body can start construction. Now, if I follow Frank's question, I'm trying to understand, the city cannot legally in Montana start construction unless the permit is issued, or because I might have misunderstood what Frank was asking, meaning we can go and say we appeal against your findings, but the city won't be able to start any construction until the permit is issued or until the city decides to build in areas and places that do not require that permit. Am I correct?
You are correct.
So I'm trying to reconcile what we just said before. How can we say we'll proceed, stop us? How does that work?
I mean, I guess it really doesn't, and that's why, again, I wasn't even alive when the statute was written, and I just had a birthday, so there. It's been a while. It is a really weird statute, so I mean, I think if they say, no, we're not going to arbitrate, we can't proceed to build it. We're just going to have to find something else to do, find some other design, or we're going to have to decide whether we want to proceed with litigation.
So, correct me if my understanding of saying, hey, we received your denial and your findings, we would be a legal process to say we appeal and oppose to your findings. So somehow this whole permit discussion gets on ice and we go back to the discussion table, or how? I do not understand what the next legal step is here.
I think the next legal step is to wait to hear from them and see if they want to arbitrate, and if they don't, then we need to have some further discussions about other designs or proceeding with litigation if that's your guys' choice.
What were the 15 days deadline about? We needed to respond to something within 15 days. And respond means, thank you very much, we'll proceed with option 0 or option 1, or we disagree with you. Is that what we need to decide tonight?
Yes, I think you guys need to decide whether or not you're just going to issue, well, I mean, I think you need to decide, I need direction as to what I'm supposed to do. Am I supposed to basically get in touch with FWP and say, we don't agree to your recommendations, you guys decide whether or not you want to arbitrate? I mean, that's a requirement under the statute. And again, do you guys want to try to pursue some mediation, some informal discussions about what arbitration looks like when nobody knows what it looks like? Or do you just want to put the ball in their court and see what happens? And then again, we're going to have some pretty serious discussions about other alternatives, or whether or not you guys want to proceed with litigation. I mean, I wish I could give you more information about the statute, but it's utterly unclear, and even the agency that's supposed to be administering it thinks it's unclear.
Unless there's additional questions for staff, I would like to open the public comment. With that said, step on up, your name and address for the record, please. And if you don't mind, honestly, try to limit your comments to about 3 minutes. Again, we have all the written public testimony. It's part of our packet this evening, plus the prior meetings dating back, as Craig said, 42 years. So, Bruce.
Good evening, Mayor and councilors. First of all, I'd just like to thank you for taking the time to have this meeting. I know it was certainly unpredicted, that it would happen. So, Bruce Booty, my address, mailing address, P.O. Box 1363, Whitefish. And I have a written comment here, but first of all, I'd just like to say one additional thing, that we are talking about this Riverbend condo segment of trail. But really what we're talking about here is the whole backbone of the Whitefish Trail system. Because it's designed along the river. It's designed to not be in traffic and in conflict with traffic, because we can all see where that is headed in Whitefish. And it's one of the few ways that we can get through Whitefish with an ADA grade and to make this trail universal design for everybody. And that's the way trails are going. It's not just ADA anymore. So we need to try to think ahead a little bit. Anyway, so I'll real quickly read my statement here. To say that the decision by Montana Fish, Wildlife and Parks to deny the 124 permit for this project is disheartening is a gross understatement. The process for this trail by itself has been underway in earnest for 20 years, but in reality it was 40 years ago that this trail was first approved by the Conservation District. So I'm sending this more or less just to say, we appreciate what you're doing, and we want you to know that you have our support, and we want you to keep moving forward on this trail segment. As a Whitefish community continues to grow, the need for this trail system is going to continue to grow. There's not any other place to go with this trail that isn't in roadways. And our roadways are already congested. It just doesn't work for the long term. And the trails are the best way to sustainably connect our community, given the constraints of the highways, the railroad, the terrain, the built environment, and the water bodies that we have to deal with. The river trail is critical to the safety and function of our transportation network. Fish, Wildlife, and Parks continue to call this a recreational trail. And that's certainly a component of it. But this is a transportation system. And this is critical to the future of whitefish. And we have not been able to get them to even acknowledge that through this whole 20-plus year process. So the segment in particular has received the highest priority rating by the community in the last growth policy round. So it's clear that the community is behind this. And I know the city highly values and cares about the physical and visual environment and in Whitefish, and has worked really hard with the citizens and with consultants to find a balanced solution that will meet all these different requirements, of which are numerous. But the response we've gotten is, no, we can't talk with you unless you file a permit. And now that we have a permit, no, we're not going to talk with you. We're just going to deny the permit. Well, this communication system is not working. It's not giving us any feedback. It's not giving us any options to even discuss with Fish, Wildlife, and Parks. So, again, I'm so happy that you folks have continued to support this, and you realize its importance to the whole community. And like I said, I know that the employees and stuff highly value this whole trail system. So I think that's the main points I have for tonight. And I'd like to thank you for your time, and hopefully one of these days we'll actually sit down and have a conversation about this with Fish, Wildlife, and Parks. Thank you.
Thanks, Bruce. Who's next? John.
I've got to start out by saying I can't possibly do it all in 3 minutes. I'll talk as fast as I can. I've got 4 examples of the type of situations where we've been treated much differently than other agencies in the state. And that's kind of what Angie was asking about. And so I'd like to talk fast, but give you examples, and I'll wrap it up as quickly as I can. And before I start that, I just want to say, we have been treated so differently than other agencies, not only in Montana, but just across the nation. Every medium to large size city that has a river has a bike path down the river, and they're usually close to the river. And usually that's fine, and they don't usually get bucked a lot by their environmental folks. Why we experience this when others don't, I don't know. But paths along rivers are commonplace, they're ubiquitous, they're not dangerous, they're not destructive, they're not harmful, they're not controversial except for us. So I want to give you some examples. The first one has to do with Spencer Lake. You've those of you who have been driving out west of town have seen that the highway's being torn up, the old highway, and dirt work's being done and trees are being cut. MDT intends to go to bid in May for the actual construction work. And so I got to look at their plans, and they have a plan for a 8-foot wide bike path. I guess it's a multi-use path from the existing end of the path in town all the way out to Twin Bridges Road. And that's great. And they're going to put it in, and they're going to pay for it. And it's on the lake side of the new highway. And it's all that dirt, all that moving is just going to result in a lot of loose soil heading down into Spencer Lake. When it's finished, the fill slope that will come down from the highway and from the path will bottom out right near the edge of the lake. And some places it'll probably run right into the lake. It's a nightmare compared to the situation we're in, and yet FWP approved it. They're going to have a trail running the length of the lake, and the lake's got a lot of fish, and they're just going to have tons of dirt until they can get it completely revegetated and those fill slopes start to hold. FWP approved that. It's a nightmare compared to our little project, but they don't care. The next one is the underpass that they built for us. So when they built the new bridge, they built us a nice concrete underpass at our request, and that was done because we wanted to continue our trial on a past the river end property, and MDT assumed we would. In fact, they had to sign an agreement saying that we would continue the path on up from the underpass. Their underpass was in the plans for the bridge, and FWP was completely aware of it. I looked at the plans. It's obvious as can be. You can't miss the fact that they're going to build a 10-foot wide concrete underpass directly in the river. It's not on the riverbank or so. It's directly in the river. And FWP approved that. So MDT can build this monstrosity. I'm glad they built it, but it's a huge concrete production. They can build it right in the river. That's okay. And then you look at our project, which is nothing compared to that. It couldn't possibly reach the level of damage that dumping this concrete thing does in the river. But FWP doesn't care. MDT can do something we couldn't possibly do. I mean, by rights, we should be able to come off of the underpass with a concrete trail all the way up the river. We don't want to do that, but if they just approved MDT doing something of that size, they really can't, they really shouldn't, they can't legally just tell us no. So it makes our little project look very little compared to what is being permitted by Region 1 of FWP. Now I'll talk quickly, I'll try. There's two Great Falls projects that were approved by FWP Region 4, the Great Falls office. One of them is on the Sun River. It has a length of a half mile. 574 feet of that is cantilevered over the Sun River. Massive amounts of concrete and steel to get it out over the river. The portion that is not cantilevered is right smack on the shore. It's close. It's nothing like what we've designed, and total thing is and it also has 1,034 feet of sheet piling up and down the river to hold everything together. Something we would never be allowed to do, and we haven't proposed to do. But that was approved by FWP in Great Falls. It's just, it's a world different. They get theirs approved, and we still haven't. There's also in Great Falls a Missouri River project. It's very similar to the Sun River project. This one was 500 feet of elevated and cantilevered trail, and also hundreds of feet of just a concrete boardwalk right beside the river. at times 3 feet away, at times 6 feet away, at times the river washes up against the concrete wall that holds it all together. Again, that was approved by FWP. We can't get that kind of treatment, and we haven't. And our little project that's not going to hurt anything compared to these, it's obvious that there's a different standard for us, and it's coming out of our local office. What they're doing violates just basic constitutional principles of equal protection under the laws. Public agencies are supposed to apply the same rules and standards to two applicants if the applicants have similar projects. You can't arbitrarily take one and not take the other, but that's exactly what's happened to us. So I encourage you to challenge this. We still have the following properties to build. The Les Schwab property, next to that is the Dalen property, the old trailer park, the old hospital, the Duck Inn, and then the area below Walgreens. All of those are going to bring up the same types of issues that we're fighting with them about now. So it's real important that we move forward and aggressively, I think, and get a decision. And I'm real confident that we'll prevail if we go to arbitration or if we go to court. So thank you.
Thank you, John. Who's next?
Good evening, I'm Mamie Flynn, and this is my daughter Abigail Kurtz. You might recognize her as a 6-year employee of Whitefish City Hall. Abby and I live at 405 Haskell Creek Road, Whitefish. Abby's also an amazing cyclist. She's a 10-year participant with the DREAM program. We're asking that you go forward with the ideas ahead in ways that honor best practices of universal design. It's important in our family, important for the Whitefish community to create forward ways that honor people in all bodies. The minimum ADA requirement that was proposed doesn't do that. It doesn't make it possible for wonderful cyclists like Abby to cycle in the most independent and safe way.
I left my bike in.
Thank you.
Thanks, Amy. Thanks, Abby, for coming tonight. Appreciate it. Keep up the good work at the city. Who's next, please? If folks don't mind lining up so we can keep this moving quickly. Richard.
Mr. Mayor, councilors, Richard Hildner, 104 5th Street. I will, in fact, try to be brief. I appreciate your comments, Mr. Mayor and councilors, with regards to this denial of your permit. The EA is incomplete, it's inadequate, and it's inaccurate. There is a lack of public participation in the process. There is a failure to substantiate factually various statements. The word could is used throughout. I could be a rocket scientist, but I'm not. But so look at what they have written in terms of could. Public safety is another major issue, and you've heard it already. You're going to hear it again, I'm sure. But I'm thinking about my neighbors at the Mountain View Manor who get to K-Beller Park and have to turn around. They can't go up the stairs. They have to turn around. I think about the parents shepherding their kids down Miles Avenue, one pushing a stroller with another child in one of those Strider bicycles running amok and down the hill in front of traffic on the highway. I look at previous and whether they're permitted or not. I was just today looking along the river at the Pine Lodge. They have a 40-foot long deck in the river. I don't know if FWP ever permitted that, and gee whiz, there might be a fish hiding underneath it. The human environment, as you have pointed out, has not been addressed. And I'm also concerned that there is no record of the communications received from third parties by the Fish, Wildlife, and Parks. Keep on moving on. Contest it.
Thanks, Richard.
Rachel Schmidt, 675 Woodside Lane. I'm going to front load this by saying I absolutely support any process that you need to take to move this forward. And I agree with a lot of the things that everyone's saying. Public safety, all of the things. I'm on record numerous times speaking on this topic. Two of the things that I want to bring up specifically is I read through the findings. I even pulled out some old textbooks on watershed management and restoration of streams. And two of the things. This analysis of this section, like this reach of stream, seems to be just looked at through just one lens. There's no context given to where this is in this river system, and no talk about the fact that it's located directly downstream from one of the most destabilized spots in the river, which is the Superfund site that continually leaks and is dug up every year. That specific spot, that loads sediment coming down the river. That does all sorts of damage. If anything, the only correct response from Fish, Wildlife, and Parks should have been, yes, we'll approve that, and what can we do in addition to the project approved to improve the stream for fish and wildlife? I mean, that was the only acceptable answer that they should have given. And so, again, you look at what the findings were saying, and I think it was kind of laughable. It was cut and paste, and there seemed to be no understanding of like all of the stream restoration that's done all the time. So this in conjunction, this project, this boardwalk in conjunction with stream restoration that a lot of people in this room know about, it's only going to improve this. But also what I found in there is it was continually, this could cause impacts. This could cause impacts there. There was never this will. It was never stated, where it was. And so those were just some brief, observations of that finding, of the findings that they had. But overall, I mean, there's just no context in where they put this. Totally support everything you guys want to do to move forward with this. And thanks for calling this meeting.
Thanks, Rachel.
Good evening, Julie Tickle, 140 Burley Bear Trail. Also here serving as the Executive Director of Dream Adaptive Recreation. You've heard from me before, so I will definitely keep it brief. Like many, very disappointed in the denial of the 124 permit. I'm here also to encourage you to stay the course with whatever course is needed to continue the design of the trail that's been proposed. And pursue a safe, barrier-free, and universally designed connected path that reflects the inclusive values of our city. As mentioned by Craig and Angie, the alternative path that was proposed is not an option. It is maybe ADA compliant, but it falls short in practice. Unnecessary elevation gains, switchbacks, people will cross the road. It'll be a path to nowhere because no one will utilize it. And a direct path is very important for families, the elderly, and the disabled amongst all of our community members. It's important to remember that the ADA was formed in 1990, and it was intended to be the minimum standard, not the gold standard. ADA compliance is the floor, not the ceiling, and I believe the city of Whitefish can and should do better than the bare minimum, and I know you all agree. This path has the opportunity to connect people of all ages and abilities, locals and visitors alike, to our natural spaces and to each other. So let's put our heads together and really focus on what's at stake here. And so again, thank you so much for all of your work. Please stay the course. please pursue the safe, direct path. You know, I've spent the last couple nights since this news came out trying to think of other options. We're adaptable. We're trying to be creative with what other options are out there, and I really can't come up with any that would pursue a universal design trail like what is being proposed. So again, thank you so much for your efforts.
Thanks, Julie. Ron.
Good evening, Mr. Mayor and Council. Ron Brunk, 640 West 5th Street here in Whitefish. I guess I first want to start off with a little disclaimer. I wasn't really a very good student in school. I crammed 2 years of college into 4, and I avoided science wherever possible. With that background, though, I question the conclusions that the FWP came up with, because this would be the same group that approved, I'm assuming, a 124 permit or a similar permit for the Memorial Bridge, as John Phelps pointed out, right downriver from it. And so I question the conclusions that they could have on our project, but they were able to approve a permit for that bridge with a lot of infilling that they did. And so I'm questioning how the conclusions for ours project negatively affects the fish, but the conclusions for the bridge didn't. And so I know that's been stated, and it will be stated again and again, but I just wanted to put my hat in the ring and encourage you to fight back against this. Thank you.
Thanks, Ron. Diane.
Diane Conradi, P.O. Box 5614 in Whitefish. The intractability of the state in this process has really left us and you as the city with very few choices. So I would encourage you to zealously pursue your constituents' needs here in a way that meets the environmental law, which I believe it can. So I mean, there are 3 tracks here legally. I'm not here to give a legal opinion. You have counsel, it's your decision. But one is the Stream Protection Act. Okay, that is the basis for the 124 permit. The other is MEPA, which is the Montana Environmental Policy Act, which is procedural. It examines proposed actions. The proposed action is the 124 permit under the Stream Protection Act. And the third is Article 2, Section 8 of the Montana Constitution, which provides the public with a meaningful right of participation. So I think the issues that I see in this process are, number one, that the state's alternative, you've heard it and you've heard why, but the alternative that they've proposed, which they're required to do under the statute, is not realistic, it's not technologically available, and it doesn't represent a logical relationship with our goals, with the proposal that was provided. Second, on the public participation, you heard it from your staff. The state's decision to issue a permit and a decision notice concurrently has locked out your ability to respond to the factual allegations that have been made in the document. You're locked out. And so I think it's essential that you reserve the right to your challenge under the Stream Protection Act. You pursue reasonable alternatives that diminish the adverse effects and consider additional legal action moving forward, whether under MEPA, whether under the Stream Protection Act, or whether pursue a constitutional claim that the public has been excluded. Now, when I say the public, I mean the city as the applicant, both from your ability to have your applicants and your technical advisors be able to respond to those allegations. And the second is that we are all here asking you to observe and honor our wishes, but we have not been allowed to do that with the state. And the state is the one who's denied the permit. So with that said, There are multiple legal avenues to pursue. Some of them are 15 days, some of them are 60 days. But I would encourage you to open the dialogue with the state.
Thanks, Diane. Regan.
Hi, thanks everyone. I'm Regan Peschel, 1412 West Lakeshore Drive, and I'm here today just to lend my voice and my community support on the River Path project. I've written in my comments in the past and also spoken before, so I'll also keep it brief. I was born and raised in Whitefish over 48 years ago, and I think this river project is a great asset to the community for many reasons, especially as Whitefish continues to grow and scale. We want to be inclusive to all trail users, including ADA compliance. This segment would create a much safer pass-through. Even myself, sometimes I think about where I want to go exercise or take my dogs for a walk, and I end up not going down there because I know it's such a truncated section, and I don't actually feel awesome about bringing my dogs even on 2 leashes across the road, and I can imagine with children and other things it could be even scarier for people. I think the 2 things that it might do to build the safer pass-through would be setting a really good precedent to continue to building trails. I think that's one of the upsides of living in Whitefish is our incredible trail system. So if we can get through this, then maybe it shows that the community loves it as much as they did and they went through something difficult and continue to put support towards keep growing trails. So thank you for your time, and I appreciate what you guys are doing.
Thanks, Regan. Joan.
Hey, good evening, Honorable Mayor and Councils. Thank you for having this meeting so quickly. My name is Joan Ehrenberg. I live at 744 Hidden Valley Drive, proudly a formal donut resident. I think it's pretty clear that the city has a pattern of striking down any of the good work that this council and this community has done. It started with our affordable housing clause, and then last session, where we had every builder allocate money or funds for affordable housing in any new developments, and that's gone. The nonprofits, 5 nonprofits were denied funding because of a miscommunication from the Long Range Planning Board, all from Whitefish, nowhere else. There's a pattern. This is a pattern of egregiously, in my mind, saying, you guys don't get what you want because and my question is, because you're Whitefish. So that's disappointing. It's more than disappointing. So I think John Phelps had a lot of good points, and Diane, and I encourage you to take a strong legal response. And then I'm thinking about what we did in the past with a scenic overlay in all roads in the county through Citizens for a Better Flathead for no billboards. So what if we look at, because this is coming, a scenic and safety overlay on all rivers and streams within our purview in Whitefish for access for a pedestrian walk, bike, roll pathway. So we can eventually have access to this before it's all developed right up to the stream. Thank you for your time.
Thanks, Joan. Fitzy.
My name's Mike Fitzgerald. I'm from 412 Lupfer, Whitefish. Thank you for doing this. We really need to get together, and this is not our first roadblock that we've had. When we first started the trail, we ran into a roadblock, and we got through it. We need to get through this, and you guys can do it. It seems like the homeowners at the condominiums put up, they've been stalling, and it's been a roadblock there, and now it's the fish, wildlife, and parks. I mean, for them to come up with some of the excuses they have as to why we can't do it are ridiculous. I mean, fish habitat, please. I'm on the river all the time. I know what's going on the river, and I know what's going on at those condos too. So I think we need to fight the fight, and you guys are up to it, and I appreciate you doing what you're doing, but we can't stop. This Miles Avenue, it's a disaster. You can't, if you're in a wheelchair or any kind of assisted transportation, it's a nightmare. And so we need to continue the roadblock right through and make it happen. Thank you very much.
Thanks, Mike. Further public comment this evening? Michelle, anyone online?
Yes, Thomas, let me bring you to the screen, and you can now have the floor. Can you, Thomas, can you unmute your mic? I can't unmute it. Try that. Try unmuting your mic. Sorry, Thomas, if you can maybe send an email and I'll make sure that I forward that on to the council tomorrow. My apologies.
Anyone else, Michelle?
No.
I'm going to go ahead and close the public comment period and turn it back to the council for preferably a motion and direction back to our city manager.
Mr. Mayor, I'd make an attempt at a motion here. I would move that we give whatever notice is required to give to Fish, Wildlife, and Parks that we significantly disagree. We would like to pursue whatever avenue they provide for us to further manage this problem. No is not an option, and for you to investigate and give us some information as to what options we might have if they simply refuse to acknowledge our disagreement. And I don't know how to make it any more clear than that. I want to make darn sure you are directed and that you make sure that we give them whatever notice within whatever period of time we have to give it to them, and we give it to them succinctly and directly, and we need to do it.
Is there a second to the motion? Seconded by Councilor Davis. Further discussion? I would just like to share that I did speak with Rebecca Norton, and her preference was to consider the alternative that FWP did offer, but I think we've heard tonight that that's just not practical or feasible, but I just wanted the record to reflect Rebecca's opinion as well. Further discussion on this matter? All those in favor, please raise your hand. Those opposed, like sign, and the motion does carry unanimously. Thanks everyone for coming. Very much appreciate it. And on that note, unless there's something further from staff, we are adjourned. Thanks everyone.
Until next time.